This issue came to my attention in a couple of ways. There's a public-spirited individual on the West Coast by the name of Carl Malamud, who for years has been running an organization devoted to capturing many of these incorporated standards and making them available to the public. From the perspective of the standards organization, it's a form of piracy. He's stealing their intellectual property and not letting them have control over it. He buys a single copy and then digitizes it, but that doesn't permit him to make it publicly available. And so there is a lawsuit, and I'm not aware of the stage the lawsuit is at, in the District of Columbia, seeking to prevent him in a particular instance from doing this sort of thing. But I'd become aware of his work and this problem, and then learned that the Administrative Conference of the United States was undertaking a study of the practice of incorporation by reference. And it resulted in some helpful recommendations that were directed to, particularly, to making the standards proposed to be incorporated available to the public during notice and comment rulemaking on a read-only basis or in some other way that would permit the public at least to know what it was that was being proposed as law and comment on it. But the Administrative Conference recommendations did not address this question of secret law. They seem to be quite happy to leave the copyright in the hands of the generating standards organization and consequently the content of the law and the control of that organization. And there's an argument to support that. The standards organizations will say that through the sale of their standards, they raise the money or some of the money that's necessary to do the work that they do, which, as I've said before, is valuable work. I think the Administrative Conference was quite influenced by that. From my perspective, secret law is simply anathema. And so the genesis of the rulemaking petition that I filed with the support of quite a number of legal academics was dissatisfaction with the willingness of the Administrative Conference to leave matters as they were in that respect. Rather, the petition sought a process in which, if a standard was to be made into a legal obligation, then the standard had to be available to the public during the notice and comment period and during the time after it had become a legal obligation. And I should go back and say again that this is different from the guidance issue. The petition did not seek, and I would not seek, to require publicity for guidance materials that involved incorporation by reference. If the public knows what the general regulatory requirement is, the technical details, which are principally what are involved in these industrial standards, are fine to be developed as they were with the reasoning that the standards institutes use for supporting their work.